I'm happy to welcome you at our third and last session of the day of our webinar. This session is fully dedicated to data protection aspects related to the implementation of the directive. For this session, I'm happy to be surrounded by excellent data privacy professionals across 8 jurisdictions, starting with Julien Hick from Belgium. He joined AKD law firm as a partner in 2021. He's a member of the Brussels Bar since 2004. He's specialized in employment and data protection law, and he assists a variety of clients from various industries, including life sciences, financial services, and consumer goods. Then Rachel Hayes from Ireland. She joined William Fry LLP in 2013. She's specialized in privacy, data protection, and cybersecurity. She advises clients in a variety of sectors on a wide range of issues, such as general compliance, global compliance programs, and regulatory audits and investigations. Caroline Landfors, now from Sweden. She's a partner at Magnusson Law Firm in Sweden. She's specializing in insurance and data protection. Prior to joining Magnusson, she served as a legal counsel and TPO in the insurance industry, first at AIG and then at Aon. Virginie Lieberman from Luxembourg. She joined Molitor Law Firm in 2007. She was admitted in Luxembourg Bar in 2008. She's a counsel head of media, data technologies, and IP practice at Molitor since 2070s. She assists clients on a wide range of information technology and communications matters, privacy matters, and data protection issues in the context of the GDPR compliance. She also specializes in employment issues, regularly advises employers on various subjects. Florencia Arredola from Spain. Florencia has been a senior associate at Bartolome Briones since 2019. She specializes in IP, privacy, and digital law. Alessandra Grandoni from Italy. She's counsel with Pavia & Saldo and member of Pavia & Saldo's compliance team. External member of supervisory board of private and listed companies as well. She's specialized in regulatory compliance, data protection law, anti-money laundering, as well as corporate liability issues. She assists clients in self-assessment process and or data breaches and inspections and defensive investigations by the authorities. Frank Becker now, the last but not the least, from Germany. Frank is the managing partner of Atsumi Sakai, which is a full-service law firm providing legal and tax advice. This law firm has the particularity to be based in Germany and in Japan as well. Frank specializes in M&A, corporate, and compliance issues, including data protection law. Frank is also the managing director of a Japanese whistleblowing service provider, GeekQuest, and has vast experience in setting up and operation of internal and external whistleblowing systems, as well as the investigation of compliance issues reported by whistleblowers. And Virginie, I don't know if Virginie has joined. I can't see her on the map. No.
I'm here.
Yes, she's there. Perfect.
So I'm happy to present our session leader, Valérie. She joined Franklin as a partner in 2021. She's a member of the Paris Bar since 2000. Valérie is specialized in IT and data protection law. She assists a large variety of clients from various industries, including technology, gaming, beauty, automotive, healthcare, insurance, financial services, and consumer goods.
Thank you, Virginie. Before we start, just have a look to the state of implementation of, yes, here it is. The state of implementation of the directive within our 8 represented jurisdictions. As you can see, only France and Sweden have partially implemented the directive. All the other countries are still in the drafting process. Concerning the French implementation law, I can say that at this stage, the implementation is only a partial one, because a lot of aspects are supposed to be explained in the future decree, which is still pending. We don't even have yet a draft of it, so that many gray areas remain, but we will see that in more details after that. How is it exactly for Sweden, Caroline? Maybe you could say a few words about the state of implementation in your country.
Sure, thanks, Valerie. The whistleblower legislation has been implemented, but the enforcement or the application of the requirement to keep internal reporting channels is staggered. So companies that have more than 250 employees, the rules on internal reporting channels apply from July this year, whereas for companies that have between 50 and 249 employees, the rules apply from December 2023.
Okay, thank you. Thank you, Caroline. So to summarize, we can say that all around the table are facing gray zones, but we have tried for this session first to ask ourselves, well, at this stage, what do we know for a fact? And what needs to be clarified? That's the purpose of the first part of this session, which is the biggest one and should take almost 2/3 of our session. Then we will focus on the ready-for-use platforms that are made available on the market and terminate with a general perspective and open question, which is, are the implementation of the reporting line a way to foster GDPR compliance within organizations? So, well, let's start with the main data protection aspect to consider. And in the first place, what we know for a fact. Sorry, I went too fast. So what we know for a fact, is that, of course, the implementation of a reporting line directly implies personal data processing activities. The fact to gather the report from the reporters is in itself a data processing activity. Even if the reporter decides to remain anonymous, the report is likely to include references to individuals directly or indirectly identifiable. The investigation which will take place as a consequence of the report will also imply personal data processing activities. The feedback to be provided to the reporter also implies data processing activities. All these implied data processing activities must, in order to be legally valid, be compliant with the GDPR. So what we know for a fact is that that GDPR applies and implies a series of requirements we already know. And to present you those requirements, we listed here the seven main requirements. It is not totally comprehensive. For instance, we decided not to go in the details of the purposes of the data processing activities, for instance. But globally, we can say that we have 7 main issues for which we have some answers. So to present you those requirements, I'll first leave the floor to Caroline Lanforth with the requirement to ground the reporting line on a valid legal basis.
Yes. So this is part of, I would say, the basics in terms of GDPR aspects. And it's, of course, that for any processing of personal data, you need to identify a legal basis. And when you have a company that has more than 50 workers, you would be in scope of the duty to keep internal reporting channels. In that case, you do have a legal obligation to comply with, which means that you can invoke legal obligation under Article 6.1c in the GDPR to motivate the processing you need to do to comply with the requirement to keep the reporting line. It becomes somewhat trickier if you're not subject to the rules on internal reporting channels, because in that case, you wouldn't have a legal obligation to invoke. In that case, you would need to rely on legitimate interest as a legal basis for the processing. But I would say that that also requires some level of work, because all of the processing that you carry out would need to pass the balancing of interest test. And if for some reason there is a processing activity you want to carry out, but that doesn't, where your legitimate interest as a company doesn't outweigh the privacy interest of the individual, in that case, you wouldn't be able to do or perform that type of processing. But it could also be the case for, say, that a business that is in scope of the reporting line rules wants to carry out some type of processing that isn't necessarily necessary to comply with the reporting line rules. Then you might want to invoke legitimate interest to carry out that type of processing outside of the scope. And in that case, that could possibly be motivated by that legitimate interest, provided, of course, that all of the other aspects of the GDPR, like the fundamental principles in Article 5, would be complied with. So I think that's it for this slide. Perhaps we could turn to the next one and see if there's local variations in place. And in this case, I think it's France and Luxembourg where perhaps you have some comments, Valerie, or those who...
From my side, it's not really a deviation. It's not only to say that, of course, the implementation of the directive can be one of the legal bases, but we also have other texts in France that makes mandatory other reporting line, and it could ground a legal basis. That's it. Just an observation, not a deviation.
Thank you.
Well, as far as Luxembourg is concerned, it's the same. It's not specific deviation, but what I would like to point out that the current bill in Luxembourg aims at applying to any violation of EU laws, but also to Luxembourg applicable laws. So it's a much broader scope of application.
Great. Right. So let's go through the second point, which is the information of individuals and rights. And for that, please, Virginie, I leave you the floor. The floor is yours.
Thank you, Valerie. So let me walk you through the question of information of individuals. So transparent information is part of the transparency principle under the GDPR, which is a key principle, of course. The directive has not so much detail about it, but what we have already is the European Data Protection Board guidelines on processing personal information within a whistleblowing scheme from December 2019. And what we see in this guideline is that we need at least a two-step procedure which must be implemented. So the first thing is traditionally a data protection notice, for example, on a website or within a public or internal facing document, but this is not sufficient at this stage. So there's a second level of information which is necessary. It's, of course, the information of all individuals affected by a whistleblowing procedure. So this information should be directly provided in a specific notice information as soon as practically possible when we use the whistleblowing scheme. And of course, during the procedure after an alert, there's a specific information to be provided to the whistleblower, to the alleged wrongdoer, to witnesses and third party which will be concerned by the procedure. So I think we can now see if there's specific deviation.
Yeah. So again, for France, there's no specific deviations, but in its guideline dedicated to the whistleblowing systems, the CNIL reminds that before the implementation of the reporting line, the company must inform and consult employee representatives body. So it's a first step in the information. And in addition, it gives some details about the general information to be provided. And that's it.
As far as Belgium is concerned, Belgium is never an easy country when it comes to languages. We've got specific rules on the use of languages when it comes to employment relationships. So that means that whenever you provide information to individuals who are employees, and that includes information about whistleblowing schemes, you need to take into account those rules on the use of languages. And to summarize them simply, it means that whenever you have your place of business in Flanders, any communications need to be in Dutch. If it's in the Walloon region, it needs to be in French. If it's in Brussels, it's either in French or Dutch, depending on the employee's spoken language.
And in Ireland, our draft bill is quite specific on this issue and data subject rights, in that it provides that data subject rights of individuals, as set out in the GDPR, for example, the right to information about processing in a data protection notice, which Regine just mentioned, are restricted in respect of relevant data. And relevant data under our draft bill is any personal data, special category personal data, or criminal-related data which are processed for the purpose of the draft bill or in connection with a report made. And this restriction firstly applies to the extent necessary and proportionate for the purposes of safeguarding the important objectives of general public interest and the protection of the reporting person or the rights and freedoms of others. And secondly, it applies to the extent and as long as necessary to prevent and address any attempts to hinder the investigation of the wrongdoing reported. And on the objectives of general public interest, this has two strands under our draft bill. The first is the effective operation of the whistleblowing legislation. And the second refers to one or more of the 15 grounds of general public interest as set out in Ireland's national data protection legislation. And this general rule under the draft bill is, the general rule under our draft legislation at the moment is that an individual needs to be informed about the restriction, unless to do so would give rise to a breach of the duty of confidentiality in relation to the identity of the reporting person, as set out in the legislation, or if it would prejudice the investigation into the wrongdoing, or if it would prejudice the objectives of general public interest. And lastly, if the individual is informed about the restriction, then they must also be informed about their right to lodge a complaint with the Data Protection Commission or to seek a judicial remedy in relation to the restriction.
Well, for Luxembourg, we have two kind of deviation, I would say. So as mentioned before, in addition to the two level of information, we have a kind of a third level of information when employee data are processed. So there must be a specific information prior the implementation of such a whistleblowing scheme to the staff delegation. And in some area, especially when the purpose of the procedure to put in place is based, for example, to safeguard the health and security of employees, then there's a kind of there's a co-decision process. So staff delegation and the data controller needs to agree prior to implement the procedure in the company. So that's a kind of a big deviation. And we have a second deviation, as Julian mentioned, for Belgium. We have also something specific regarding the use of languages. So what the bill said currently that we can use, of course, one of Luxembourg official languages, which is French, German, or Luxembourgish. And it's also authorized to use another language, which it is a common language used in the company. So English mainly is also authorized.
And for Sweden, we haven't gold-plated the information requirements, but we've rather sort of introduced an exemption that applies when, for example, there's an ongoing follow-up. So companies that would otherwise need to inform the person concerned don't have to, given the obligation to keep the follow-up confidential that's been introduced in local law.
Great. Thank you. Let's look now to the restriction of access.
Thank you.
Here.
Thank you, Valerie. Okay, so we all know that disclosing a fraud is not easy because whistleblowers might face threats to their career and to their safety. In this sense, the whistleblower intention to disclose a fraud can be enhanced by the organization's warranty and response. One of the best methods to avoid the retaliation against the whistleblower is to keep their identities hidden. In this respect, the whistleblower directive established that the channels for receiving the report must be designed, established, and operated in a secure manner. So in this way, they can ensure the confidentiality of the information provided by the whistleblower. All the member states shall ensure that the identity of the whistleblower and that of any other person that is mentioned in the report are not disclosed, and is not disclosed to anyone beyond the authorized staff which is competent to receive or to follow up these reports. The confidentiality obligations applies to all the information except in these cases where the explicit consent has been provided or when the information is in the context of an investigation or in an investigation or judicial procedure. You may ask, which is the information protected? Well, the confidentiality obligations applies to the identity of the whistleblowers and, of course, of any other person mentioned in the report, but also to any other information from which the identity of this person might be directly or indirectly deduced. Also, the confidentiality obligation applies to personal information such as working relations, economic or social behaviors. Okay, so entities shall also apply the minimization principle, which is set in the GDPR as well. So this means that the data protection, which is clearly not relevant for the allegation, should be not processed. For example, if the whistleblower reports that a colleague has committed a fraud and within his statement discloses information about this colleague's health situation, so this information will be clearly irrelevant for the case and therefore should not be processed further. Okay, so who are the protected subjects? Of course, it's the whistleblower, but also there are all the other persons that appear in the report. For example, the potential wrongdoer, the witnesses, the colleagues, or any other that is mentioned in the report. The identity and the personal information of all of them must be also protected. With regards to the security measures, it's relevant to mention that entities shall implement the corresponding technical and organizational measures to ensure an appropriate level of security. Which is the level of security? Well, this will depend on the risk derived from the processing and also from the nature of the information that is being processed. The need and the selection of the security measure must be analyzed. But for example, we can mention to reinforce the obligation of secrecy of the authorized staff, limiting and controlling who has the access to the whistleblower cases and to the accessing logos, and perhaps encryption should be especially considered due to the high needs of confidentiality of this kind of information. Well, who can access to the information on the report? Entities are obliged to designate an impartial person or the whole department competent to receive reports and to follow up and ask for further information to the reporting person. And the last point, in relation to the access right of the person who breaches of the law is attributed. As you must know, by means of this access right, the person will be able to know how and why his or her personal data is being processed. Therefore, before providing this information, all the personal information of third parties, such as the whistleblower or the witnesses, should be removed from the document. However, in cases where even if the whistleblower name is deleted from the document, his identity will be obvious because of the reference to specific events or situation or the context described, then the right of access should be, if possible, addressed in more general way. But if this is still not possible, it might be necessary to withhold the disclosure of an individual personal data on the basis that this will interfere with the rights and freedom of another individual. So the balance between the right of access and the confidentiality needs to be assessed on a case-by-case basis. So this is basically which is the restriction to the information means and refer. So now we can see if there is any deviation from the jurisdiction. I don't think there is any mention here.
I think that we have no deviation, but precision maybe for Sweden. Caroline?
Yeah, so it's not a deviation that's introduced due to the whistleblower legislation, but it might be good to know that we do have pre-existing deviations that, for example, for confidentiality reasons, restricts access to data subjects.
My microphone was off. Thank you. So let's move to the other point, which are the technical and organizational measures that needs to be put in place. And for that, I leave the floor to Alessandra Grandoni.
Thank you, Valerie. And from a technical and practical standpoint, very often companies make use of software provided by external suppliers acting as processor from a data protection perspective. In this situation, the duty to ensure the proper functionality of the software, as well as the privacy by design conformity and the fit for use, does not lie only on the external supplier of the software. It is prudent that each company acting as controller before implementing the software carries out its own technical checks and possibly also a vulnerability assessment to, in the view of minimizing the risk of potential non-conformities of the line and also be compliant with the accountability principle. The technical measures, more in particular, should include at least the encryption of information about the reporting person, the breaches in itself, and related documents. It is also important that the access to the whistleblowing channel is not traced through firewall logs or any equivalent instrument. And it is also necessary that the organization operating the whistleblowing channel shut down the technologies able to remember the users of the channel, because this technology could result in conflict with the duty of confidentiality. It is also essential that the supplier of the software is a reliable processor, and that the relationship between the processor and the controller is governed by a written contract. And also technical instruction should be provided to the processors. It is also important to check where the server hosting data is located to avoid the risk that any data is exported outside the European Economic Area without appropriate safeguards. From an organizational standpoint, it is important that the organization adopts policies according to which the access to the personal information is strictly limited on a need-to-know basis. It is also important to adopt a sort of whistleblower policy and handling procedure policies, which should be written as much as possible in a plain language. These documents should be user-friendly, I would say, and easy understandable by all employees. Last but not least, it is important to promote inside the corporate organization a speak up and listen up culture, a sort of dialogue. For any employee to speak up, there should be someone from the management who is willing to listen and to understand. And from this point of view, organization can assure this by providing safe reporting channel and demonstrating their commitment to receive and address reports of breaches. In conclusion of this short overview about technical and organizational measures, I think it could be interesting to see whether in other jurisdictions there could be any deviation according to the local transposition laws. For example, in France and in Ireland.
So in France, it's not the deviation. It's just to point out that in France, the whistleblowing guidelines of the CNIL, there are some terms, minimum terms, which are included in it. So it's really key to have a look to them in order to be safe.
Yeah, and in Ireland, it's not so much a deviation either. It's more an extension on minimum requirements. But our draft bill specifies that any relevant person who is a controller of relevant data has to implement technical and organizational measures to prevent the abuse or unlawful processing of that data. And the bill lists various measures to implement, such as using secure storage, passwords, encryption, role-based access controls. It also mentions adherence to the GDPR's data minimization principle, including the use of anonymization or pseudonymization techniques where appropriate. And it also mentions deleting any data without undue delay where it's manifestly not relevant to the handling of a specific report.
Thank you. Let's move now to the specific agreements with processors. Just to give you one information, because I'm also the timekeeper here, we are a bit behind. We can go a bit quicker, it would be wonderful.
That's noted, Valerie. Thank you.
Yes, it was for you.
Thank you. Perhaps just a bit of an explanation for those who may not be familiar with the notion about what a processor is. A processor is, in essence, a provider or party which you are using in order to process data on your behalf and under your instructions. So in the context of whistleblowing, there's probably two situations where you could come across processors. That's either if you use an external party to provide whistleblowing services, whistleblowing platform typically. Another example can be if you share resources internally within your group and you use another group company to provide services related to whistleblowing, which involve the processing of personal data. So these are processors and how you come across them in the context of whistleblowing. Now, if you want to use processors, there's basically two types of requirements that derive from GDPR. The first one is about choosing your processor correctly. It's about making sure that you are engaging with a party that has the capacity that offers sufficient guarantees in terms of technical and organizational security. So that requires a bit of due diligence before you decide to call upon the services of a specific processor. And ideally, that due diligence exercise should be documented so that if you ever get audited, you can show what criteria you used in order to select your processor. That's one aspect. The other aspect is the obligation to have a specific agreement with the processor. And the GDPR lists a number of topics that must mandatorily be addressed in that agreement. First one is obviously the details of processing and what the processor will concretely do, in what context it takes place, what type of data it will come across. And that's a pretty important one in the context of whistleblowing because it may involve sensitive data. It may involve, for example, data about potentially criminally sanctioned behavior. So that description of processing activities is quite important. Also to make sure that the processor knows what he's actually doing with your data, what data we're talking about. That the processor only acts on your instructions. So if you engage an external platform, they will do what you tell them to do and exclusively what you tell them to do. So you are in the driver's seat as an employer, as a company, and you determine what they may or may not do. Obviously, they need to ensure that their employees are held by confidentiality obligations. Alessandra just said a word about technical and organizational security measures. Well, obviously, if you need to take them as a company, you also need to impose them on processors. Externalizing processing is no excuse for not taking adequate measures, and these need to be laid down in a contract. It may happen that a processor uses sub-processors. For example, imagine that you use a platform hosting company, and that platform itself uses an external IT provider to store data. That's a sub-processor that hosts data on behalf of the processor you have engaged. Well, your agreement with your processor needs to provide that your processor needs to have another agreement with the sub-processor that basically states imposes the exact same obligations as those you have imposed to your processor. So it's sort of back-to-back agreement, so that any use of sub-processors do not jeopardize the protections which you have provided in your agreements with your own processor. You may come across data subject requests, right to access, right to correct data, and so on. Well, your agreement needs to provide that you get assistance from your processor in responding to those requests. You also need to address the topic of deletion or restitution of data when the processing stops. So that needs to be addressed in your agreement. And the last thing is processors need to document what they do, how they comply with your obligations, and you should be able to audit that they effectively comply with the obligations you have imposed, and that needs to be provided in your agreement with your processor as well. So in a nutshell, that's what you need to include in those agreements. So if you move to the next slide, then we will see that in a rare display of EU unanimity, there are no local deviations. And what I just said applies to all countries on this panel.
Perfect. One fits all. So then let's move to the need for a data protection impact assessment, a DPIA. And for that, I leave the floor to Frank Becker.
Thank you, Valérie. There are certain opportunities or certain cases where under the GDPR you need, before engaging into a certain kind of data processing, need to do what is called a data protection impact assessment, which is described in Article 35 of the GDPR. And this requires the controllers to prepare such an assessment if the concerned activity is likely to result in a high risk to the rights and freedoms of natural persons, which can be the case if large amount of data, sensitive data is processed, or other cases named by the law or included in lists that the local data protection authority compose. And for the case of whistleblowing, it is largely clear that and the common view that a data protection impact assessment should be conducted. When should it be conducted? This should be done at the initial stage of implementing the whistleblowing policy, and before you start processing data within the whistleblowing system. How should you do it? Usually, if you're required to have a whistleblowing hotline, if you're a company large enough, usually in German mandatorily, due to the size of the sort of people, you will have a data protection officer, which should really be your first to go. It can be either internal or external, and also you should include HR team and IT team in order to draw up a DPIA. What exactly is to be included in the DPIA? Well, first of all, you need to describe the processing activities you're planning, then you need to explain why such processing is necessary and what the controller's legitimate interests are. That can be, for example, legal compliance within the organization. It can be also, in some cases, legitimate interest. It can be, then you need to clarify that there is no other way, less intrusive, to achieve the same purposes. You have to sort of foresee the potential risk here, the risk for the whistleblower and for the person being reported, and you have to list out the measures you have taken to mitigate any such risks. So generally, the recommendation is really that you would take a standard form from which is often provided from the local authorities, which helps you sort of making such a data protection impact assessment, which shows you where to write what. Sometimes it's with colors indicating risks. It is important to do that, and please involve DPO, HR, IT, and that brings us to the deviations. And I think there are hardly any, and please let me use this opportunity for Germany to say that there are no specific deviations on any of the points in Germany, just because the German legislator, at least so far, we are still in the draft stage, takes the position that everything that is relevant is already within the GDPR or the local German data protection law. So no deviations anywhere for Germany. But yeah.
Thank you, Frank. From France's perspective, the only point is that there is no, you need to perform a DPIA. It's not, but the question is definitively solved because CNIL said that, well, whistleblowing hotline is in the list of the mandatory DPIA. So no, it's not questionable anymore for France.
And it's the opposite in Ireland to a certain degree, in that no specific derogations or deviations, I should say, but whistleblowing systems are not included in the Data Protection Commission's list of processing activities requiring a DPIA.
It's interesting. So that we definitively see that sometimes just the opposite which applies. And let's move now to our last point, the restrictions on international transfers to non-adequate jurisdictions. And Rachel, it's for you.
So I'll try to be quick on this topic, but a necessary part of how a report is handled or investigated, or even operating reporting channels or procedures, may involve the processing of personal data which originates from the European Economic Area, and that data subsequently being processed from outside of the EEA. So this could arise, for example, with intergroup transfers, from an EU-based controller to a non-EU-based controller, for example, in the US, or it could arise between EU-based controllers or processors with non-EEA-based service providers, for example, a hotline provider. And when this type of cross-border processing takes place, a transfer of personal data is triggered under Chapter 5 of the GDPR. And it means that the transfer needs to be legitimized to comply with the GDPR. And this slide is kind of just a quick overview of how transfers of personal data from EEA-based controllers or processors to non-EEA-based controllers or processors may be legitimized under the GDPR. And just to be clear, a data transfer under the GDPR goes in one direction, And that is when the data are being transferred from outside of the EA to the non-EA country and not in each direction. And the main compliance obligation from a GDPR perspective is to ensure that the transfer does not undermine the level of data protection which is given to personal data in the EU under the GDPR. And as you can see on the slide, there's various mechanisms which may be used to legitimately transfer personal data from outside of the EEA. The first mechanism is to assess if you can rely on an adequacy decision. And this essentially means that the European Commission has deemed a particular country adequate in terms of its national laws and practices, meaning that the data can freely flow there to that country. And currently there are 13 countries which are deemed adequate, and some examples are the UK, Japan, Switzerland and Argentina. And if there's no adequacy decision for the country of transfer, then the next step is to assess what other appropriate safeguard is available. And the main appropriate safeguards currently are binding corporate rules, also known as BCRs, which are applicable to intergroup data transfers and sharing. And then the more commonly known one are the standard contractual clauses, again, often referred to as the SCCs. And the SCCs are essentially pre-drafted clauses prepared by the European Commission. And they were recently updated in June of last year, and they cater to most data transfer scenarios and data protection relationships. And if the SCCs or the BCRs are the transfer mechanism being relied on, then a documented assessment known as a transfer impact assessment needs to be carried out in advance of the transfer. And that's to assess if the local laws and practices of the relevant third country offer a level of data protection which is essentially equivalent to the standard afforded in the EU under the GDPR. And this documented assessment arose from a Court of Justice decision in July of 2020, known as Schrems 2. And if there are any gaps identified in the transfer impact assessment in the local laws or practices of the country of transfer, then the supplemental measures of a technical, organisational or contractual nature will need to be implemented. And lastly, just to mention very briefly that derogations may also be possible to rely on in very specific situations, subject to certain requirements, which are set out in Article 49 of the GDPR, where the previous mechanisms I just mentioned can't be relied on. And the derogations offer various potential legal bases to transfer personal data outside of the EA, where the processing is non-repetitive or occasional in nature. And to move on to the next slide, and to borrow Julian's phrase, in that this is again another rare display of unity, in that the same rules apply in each of the 8 countries.
Exactly, once it fits all as well. Thank you. So, well, let's see now what needs to be clarified. Of course, it's only a selection. We are by no means exhaustive here, but we wanted to focus on 2 issues that we understand are of frequent concern to our clients. So the first one are the requirements for the implementation of a shared whistleblowing hotline within groups. And the second one is how access right can be restricted in case of whistleblowing complaint. So we already talked about the second point, but we will maybe go a bit in more details to it. So our first point, so how to implement a shared whistleblowing hotline within groups. So what the directive says is that legal entities in the private sectors with 50 to 249 workers may share resources as regard the receipt of reports and any investigation to be carried out. But what does this exactly mean? This is one of the biggest gray area of the directive, which has a direct impact on GDPR compliance, as it will influence the contents of the data processing agreements to be executed and or the information notice to be provided to the reporters and to individuals named in the reports. So in order to have an idea about what means shared resources, Of course, we had a look to the Commission Group of Experts interpretation. Just briefly, the Commission Group of Experts is the group of experts with the mission to interpret the text in order to provide some guidance to the various member states for their work of implementation. But it's only guidance. It's not mandatory upon the Commission. And what the Commission Group of Experts says is that sharing resources does not mean that it allows corporate groups to only establish reporting channel in a centralized manner at a group level, first point. And it also says that you can implement a single reporting channel, provided that these reporting channels remain available at the subsidiary level. Then there is a clear information which is provided to the reporting persons as to the fact that as a designated person or department at headquarters level would be authorized to access the report for the purpose of carrying out the necessary investigation. And the reporting person has the right to object and to request investigations at the level of the subsidiary. And last requirements, any other follow-up measures is taken and feedback to the reporting person is given at the subsidiary level. In other words, should we summarize that? This means that groups of companies can implement a centralized reporting line, but there should always be a reporting line at the subsidiary level. A single centralized reporting channel on the parent company is forbidden. The other companies with which the resources are shared can access the report for the only purpose of carrying out the necessary investigations, and the reporter must have the option to object to these shared resources. And any other follow-up or feedback must always be provided at the subsidiary level. This interpretation of sharing resources is thus quite restrictive and seems to go beyond what is expressly provided in the directive. But as I explained, the Commission Expert Group interpretation is only guidance for the various states in order to help them to implement the directive in their own jurisdiction. So let's see now how it has been used for the various states around the table for the implementation work. Should we go to the French position? It's totally unclear at this stage. Totally unclear because I will show you the text of the implementation. So what the law says at this stage is just medium-sized companies may pool their procedures for collecting and processing alerts in compliance with the future decree, I said, which is still pending. And a bit later in the text, it is said, the procedure for collecting and processing alerts may be common to several or all of the companies in a group in accordance with the terms and conditions set by decree. So with that, we don't know where we are because the term procedure versus resources used in the directive is totally different. So we don't know at this stage whether the term procedure is equal to resources or if it's something else. Secondly, there is nothing in the text for the moment about the Commission Group expert conditions, nothing. Maybe it will be included in the decree, but at this stage, nothing is said. And lastly, there is an ambiguity in the text because as it is drafted, it could be interpreted as within the group, you can share the resources, whatever the size of the affiliates. Because as you can see in the second paragraph, there's no reference, explicit reference to the size of the companies. So is it something which was just missed and that will be re-explained in the decree or not? At this stage, we don't know. So hopefully the future application decree will clarify all this, but for the moment, it's just a complete nightmare, very big gray zone, I would say. So I think that on the contrary, Caroline, just let me know if I'm wrong. No deviations have been included in the partial implementation of the directive in Sweden. You confirm?
That's right.
Okay. So let's move now to the second point. How access right can be restricted in case of a whistleblowing complaint. So the recital of the 84 of the directive refers to Article 23 of the GDPR, which gives the possibility to the member states to limit the obligation and rights under, among other, Article 15. So it's an option which is already given to the various member states. The various member states can go beyond what is said in the GDPR concerning the limitation of certain rights, and including the rights to have access and obtain a copy of the personal data which are processed by a data controller. In the GDPR, what is said in general is just, well, the Article 15 shall not adversely affect the rights and freedom of others. And this includes, of course, the data privacy rights of others. That's what was said when you are providing them information, some feedback. You need to delete the reference to the other individuals in order to be safe on this side. And so this includes the privacy of others, but also the trade secrets of a company or the IP of a company or of an individual. So that's the common limits, but the member state can go beyond that. And maybe we'll have a look to what is stated in the various countries. For France, there's no specific deviations, but just wanted to point out the fact that for employee access right requests, the CNIL has recently issued a comprehensive guideline, which is really interesting and help data controllers to answer to access right requests. And that's all.
And in Ireland, it's the same provision in our draft bill that I mentioned at the start, in that the restriction, all rights of data subjects can be restricted where it's necessary and proportionate for safeguarding the objectives of general public interest. And it also mirrors the language in Article 15.4 in that, you know, it's to protect the individual, but also the rights and freedom of others. And it's only to the extent and for as long as it's necessary to prevent and address any attempts to hinder the investigation of the wrongdoing.
And for Sweden, as I mentioned previously, there's no new legislation due to the whistleblower directive. But when Sweden implemented the GDPR back in 2018, we also introduced local provisions that made it possible to deviate from access rights and information requirements when it comes to issues that the controller is under a duty of confidentiality not to disclose.
Thank you. Thank you. And now let's move to our two last points. The first one is about the do's and don'ts of ready-for-use whistleblowing platforms, which are made available on the market. And for this, Julien, I give you the floor.
Thank you very much, Valerie. In interest of time, I'll limit myself to a couple of thoughts or points which regularly come across when you see those types of platforms. I think an interesting thing, if you look at those platforms, is most of them were designed or created with the first wave of whistleblowing schemes, and I mean thereby those that were implemented in the aftermath of the Enron scandal and Sarbanes-Oxley legislation in the US, which in essence imposed US companies with overseas activities or US companies listed on stock markets to implement whistleblowing schemes in the US, but also within their local subsidiaries, including in Europe. And what we very much saw at that moment were standardized platforms intended to report essentially accounting fraud, tax breaches in a centralized way. And if you look at the directive and the way it's been implemented in those states which have already implemented it, but if you also look at the recommendations from the groups of experts, I think the philosophy of those platforms as they've been designed will probably need to be changed a bit, or at least they will need to be flexible when implementing schemes in Europe, taking into account a number of things. The first one, as you pointed out, Valérie, is the need for reporting channels at subsidiary level. So it means that whenever you're operating within a group of companies that has European subsidiaries, you will need to have some sort of local ring-fenced system that is not centralized, or at least not in the way those systems were initially conceived. And that is something platforms will definitely need to take into account when offering their services. I briefly touched upon it as well when speaking earlier. Virginie did it as well. Most of these platforms, with a few notable exceptions, are US based and traditionally offer reporting channels in English. Well, that is also something that they will need to be flexible on, because a number of European countries have rules on the subject, and reporting will obviously need to be something employees can do in their own language. The last point I was touching upon is the scope of potential reports. Many whistleblowing schemes were created, as I said, in order to report accounting fraud, tax breaches, those types of breaches we saw that basically led to the Enron scandal and Sarbanes-Oxley. If you look at the material scope of the directive, it's actually much broader than what those schemes were initially intended for. So that also means that to some extent the platforms will need to be designed in order to be able to report other facts than those they were usually accustomed to. And it also means that on the receiving end, you will need to have people who can appropriately sort out reports and understand what they're about, so that appropriate investigations can actually be launched. Now, if we move to the second question, which is specifically targeted on US whistleblowing transfers, I think there's still future for those whistleblowing platforms, for the very simple reason that most of those platforms initially came from the US, so we have to acknowledge that they have some experience that we may not have in Europe on the subject. So I would definitely not throw them in the bin. On the contrary, they're not forbidden, and they probably have a bright future, I guess. But a certain number of things will indeed need to be taken into account if you intend to use them. Most of them will imply overseas transfers of personal data, which means you will need to ensure whenever you contract out those platforms that you have appropriate standard contractual clauses for the transfer of personal data in place, and that is a very important subject to be checked, and that's a subject that's high on the agenda of data protection authorities nowadays. Very, very narrow audits on that subject. And I think the second thing is the paramount importance of the transfer impact assessment. Having SCCs in place is no longer sufficient to transfer data abroad. It's really something you need to take seriously. It's really about checking what types of guarantees can be offered in a country where the data is going to be transferred, and where necessary, taking additional measures to make sure that that data is adequately protected, such as encryption, for example. So I guess these points are really important and to be checked, especially in the terms and conditions offered by those platforms, which tend to be standard terms. So yeah, better safe than sorry in that case.
Thank you, Julien. And yes, sometimes it's quite difficult to find in the general terms and conditions all those documents, including the Trans 2 assessment that Rachel mentioned a bit earlier. Yeah, sure. Then our last point, whistleblowing schemes as a way to foster GDPR compliance within organization. So Will this increase the risk of employee claims or a report based on GDPR non-compliance? Will this accelerate companies' internal compliance programs? We discussed this around the table, and based on our discussions, we really did not know the answer. It could really be maybe yes, maybe no. So we went a bit further and tried to find statistics around this, and we found some. We had a look to that. We had a look to the benchmark report 2022 of NAVEX, which is an editor of quite well-known ready-for-use platform. And what we discovered is that data protection non-compliance reported through the reporting lines powered by NAVEX are very numerous. They are the third category of non-compliance reported. So in this context, if the number of reporting lines increase, the number of data privacy non-compliance reported should also increase. This may increase the risk of employee claims based on GDPR non-compliance and should accelerate companies' internal compliance program. So, of course, this is only a prospective thought and not a certainty, but now we have some clue in order to assess the question. And I think that here we are. So we have 4 minutes left for the questions. So I don't know how many questions we have, but maybe one of interest would be non-compliant whistleblowing hotline. What is the risk in the end? Because that's key. If there is no risk, of course we won't perform all this. So there is a real risk, of course, which is the risk based on GDPR non-compliance, and that would amount in fines up to if my memory is okay, I think it's 20%. No, it's 20 million euros and 4% of the total turnaround of the year, the past year for the group of company. Of course, it's maximum, and the various authorities just do not apply such amounts, but we have some decisions in the various jurisdictions where quite important fines have been issued. So maybe around the table, someone would like to give us a few words about that.
Well, Valerie, thank you. Well, as we mentioned, there are many risks. Well, a company that has not implemented a whistleblowing scheme or has not a compliant whistleblowing procedure can face various risks. We can talk, but we don't have time, about reputational risk, for example, or governance risk. That's a possibility. As far as Luxembourg is concerned, and when we look into the bill, what we saw is that in case of non-compliance with the provision relating to the obligation to establish internal reporting channel in the private sector, the competent authority may impose its administrative fine amounting to 1,500 euro to 2,500 euro. So that's a potential sanction, and also either in specific law there are additional fines or provision in sectorial law that can be applied together to what we have in Luxembourg.
I think that for Spain is more or less the same situation. So the draft of the law stated that infringement could lead to a sanction up to 1 million euros. So we need to wait until the law is effective, but at least from the draft, we can mention that the fine could reach up to 1 million euros.
Yeah. So, and there is also the reputational risk, because I don't know how it was in the various decisions, but Sometimes the authority wants to point out the non-compliance and just issue the decision, and it is really in this case that it becomes a nightmare. Yes, Julien, sorry.
No problem. Perhaps just an additional risk I'd like to point out: if you implement a whistleblowing scheme that doesn't comply with data protection requirements, it's not only about financial risks, but it can also be a risk in terms of having the ability to dismiss an employee based on the outcome of your investigation, or in dismissing your employee but facing challenges in court about the validity of evidence that's been gathered. And I think France has sort of the same reasoning, if I'm not mistaken, that our courts say, well, look, if evidence has been illegally obtained because it's been obtained through a whistleblowing challenge that is not complying with data protection requirements, then that evidence is simply set aside.
Exactly.
Which means that you may have, or think that you have the very best case to dismiss an employee, and then at the end of the day still lose on a technicality because what looked pretty strong evidence appears to have been collected illegally. So I think that's one to think about as well, and certainly a good reason to do things in a compliant way.
Fully agree with you. I'm sorry, we have other questions, especially about the implementation of global whistleblowing hotline within global entity, partially based in the US and in Europe. We will answer those questions separately after our session. I'm sorry, we are really running out of time. We need to stop here our discussions, which were really, really interesting. It has been a real pleasure to present this session with all my dear friends from great law firms. Thank you for your attention and have a wonderful evening.